Hello.
Hello, ma'am.
Yeah.
Yes.
Yeah. Are you ready?
Good afternoon. Yes, ma'am, we are ready.
Good
I
afternoon.
hope.
Yeah.
Yes, I hope you are ready as well. You
Yeah.
want
I
to
am
take
ready. No, I am ready. I am ready.
All right, ma'am. So first, I'll just give a quick introduction
Yeah.
to all the participants here.
You are
So
Ridhima Nair? Yes.
yes, ma'am, Ridhima Nair.
Okay. Yeah. Okay.
Yes, ma'am. So shall I start then?
Yeah. We can start.
Okay, ma'am. Okay, ma'am. Yes. So hello, welcome you all to today's webinar by Peer Support Network, LC1, Delhi University. I'm Ridhima Nair and I'll be your moderator for today. We are so excited you guys were able to join us today. I know we're going through some rough times, but we hope to bridge the gap and by learning together as a team. So today we have with us Dr. PB Pankaja, ma'am. Ma'am is going to address us on the topic of subject guidance and answer writing for family law. And we are grateful to have you with us, ma'am.
Yeah.
Ma'am, would you like to say something about yourself?
Yeah. I will introduce. Shall I start?
Yes, ma'am, absolutely.
Yeah. Good afternoon, everybody. My dear students and all the viewers. At the outset, I thank Ridhima Nair for introducing me to this webinar session. And my heartful greetings to this PeerNet Support Network for your wonderful work that you are doing in coordinating certain important sessions, online sessions, for the benefit of the students of the entire law faculty. And not only it has some open access to everybody also. I think all the students throughout India also can view it. So
Right.
I congratulate you and keep it up. And my sincere greetings to your success in your endeavor, this new endeavor. Then I welcome all the viewers and the students for my webinar session today. And I would like to give you my session through PPT. I have prepared some slides so that you can understand the concepts very clearly. So you can focus my,
Absolutely, ma'am. And before that, I would want to ask you something. So in between, if anyone has any doubts regarding a particular topic, is that okay if I ask you in between?
I think after I complete, I have some 13, 14 slides.
Okay.
I will be covering the entire syllabus, and
Okay.
I have taken out one approach. So I think it would be better I complete it. Then interaction ke liye we can just leave some time. The students can pen down their notes, that is their clarifications, and they can ask. I think that will be, because otherwise we will be deviating. I will be deviating, and we have to manage time also. So can I know how much time I am given for this webinar? What is my time?
Ma'am, we actually plan for 1 hour, but if you want to extend, that's also fine. In case we are able to, finish our questions within that time frame, that's also fine. But you take your time, no problem at all.
Okay. I am comfortable with 1 hour or even 1 hour 15 minutes also.
Yes,
I can also take questions. Yeah, I can also take questions after my lecture. Okay.
Okay, ma'am. Okay, sure.
Yeah. Okay, ma'am. So, am I visible?
Yes, ma'am, you are. Just let me know if you can share your screen. I'll check from my side as well.
Yeah. Because your screen is visible to me.
Yes, ma'am.
Yeah. I don't know where is my space. please tell me whether all the participants are muted.
Yes, ma'am. Yes, ma'am, they are.
Okay.
They are muted. Are you able to share your screen now?
Yeah. Please share. Are you able to?
No, ma'am, we cannot see the slides.
No. You please share. First of all, let me be visible to the students.
Okay. So you want me to share the screen?
Yeah.
The PPT?
Yeah.
All right.
Yeah. I want you to share the screen to me.
Okay, ma'am. But so have you mailed us the PPT? I'll just check with the team once.
No. It is with me. I will share the PPT from my system.
Yes, ma'am. So you will have to present the screen then. This way, in case you have the PPT, you will have to present the screen and then we'll be able to see what you're presenting us.
Is it visible now?
Yes, ma'am, absolutely. Perfectly visible.
Yeah. So now I am into the session. Everybody ready?
Yes, ma'am.
Yeah, okay. So today's session is, I think it is very, very important because we are doing everything online, and this webinar is also online, and it is a good experience for everybody to become more and more computer savvy, to learn all technological nuances. And I thank the organizers for giving me this opportunity. And I also welcome all the students. I have given a brief account of, because the time, there is a time limit. So it is in between 1 to 1 minutes. That is what I am told. So I will try to give a glimpse of the syllabus, that is what are the things that you have to learn, what are the highlights, what are the very important points that you have to look into. All these things I would like to present it, and I'll reserve the interactive session at the end, because you please pen down all the clarifications that you require and the queries, and I will be able to do justice. Okay, so this is, I have taken up this, how to read and give exam in family law 2. I am confining only to family law 2 and a very few guidelines. So it is up to everybody to accept the guidelines, because these are in the nature of guidelines, and everyone will have his or her own method of preparing for the exam. And we cannot say that this is the best method and that is not the best method, according to one convenience, because exam is a routine thing that has been happening in our academics, and you might have also given so many exams. So it is not a difficult thing for you to tell you how to face the exam, etc. So a few guidelines I have taken up. I have charted out certain guidelines, how you will attempt family law 2. There are certain specialities. Each subject will have law subject, certain specialities. Even among the law subjects, family law 2 has certain unique features. And so what are the unique features, how you have to face them, and how you have to handle them. And this regarding this, I am going to share certain guidelines. So these guidelines are good to you. They will be helpful to you as per our previous practice. That means where you have to give your exam physically with pen and paper. So on that model, I have prepared these guidelines. And this is not for open book system, which nowadays we are coming up with this mode of examination also from UTC and MHRD, that final year students will take up open book system. So these guidelines may not be useful for open book system, but for previous conventional examination writing pattern. And I hope that these guidelines will be of some help to you. Okay. So I start this webinar with certain presumptions that I cannot start with scratch. I cannot give you the facts, everything from case 1 to case 30. And I go by with these presumptions that you have given at least a single reading of all the cases in your case material. And some you might have heard in the classroom, physical classroom, and the others, I think all the students might have heard from online classes from your concerned teachers. And I think by this time, our family law syllabus is over. I think the coverage is over. And it is now the duty shifts on the students to make use of the time and also prepare for the exams. And so with this presumption that you have at least given a single reading of all the cases, and you have participated in online classes by your concerned teacher also, and these guidelines I think will be of some help to you. So with this big presumption, I take you to the segments of your syllabus. So you please refresh on the syllabus topics. You have Hindu law and Muslim law. And in Hindu law, there are 7 topics, and under Muslim law, 3 topics. And no one topic is deleted for the examination, and all the topics are to be covered. And Hindu law has 7 topics. Topic 1, Hindu joint family and co-pastory, judicial and legislative trends. I want to highlight this because that topic has certain segments, but among those segments, the commonly asked question is, what are the legislative trends with regard to Hindu joint family and co-pastory? As against that, I have also marked, hinted the rough marking system. It is only a rough marking system. They are not a fixed pattern. And you may have to prepare for 20 to 25 marks for this Hindu joint family system. And the next subtopic is alienation of joint family properties. That means whether the karta can alienate, who can challenge the alienation, etc., etc. So now that is for tentatively 20 marks, partition 10 marks, and the 4th topic is general principles of inheritance, that is succession to a male Hindu, section 6, which includes notional partition, and sections 24 to 28, that is disqualifications, and the marks, tentative marks can be 20 to 30. Next, on par with succession to male Hindu and succession to property is okay. The 4th topic is the general principles of inheritance, and the 5th topic is succession to the properties of male Hindu, section 8 to 13 specifically, the rules relating to it. Next subtopic is succession to the properties of female Hindu, section 15 and 16. And lastly, Hindu women's estate, section 14. Okay, so these are the segments that you can find you have to prepare under Hindu law. And under Muslim law, comparatively, only 3 topics are there. They are less in number: law relating to gift called hiba, law relating to will, and Muslim law of inheritance. So in total, we have 10 segments. Okay, 10 topics are there. And next, what is the pattern of question? Because you have already taken your first semester exam. This is only your second semester exam, and you will be finding question on the basis of marks. You may be finding 5 marks question, 10 marks question, and 20 marks question. So this is the large question, and this may be, it is neither a short question nor a big answer. And this is how, on the basis of marks, your question paper may have these 3 types of questions. Now, on the basis of content, there can be theoretical questions and case law based question, because theory part also constitute an important way of explaining the joint family and co-parcenary system. And so theoretical aspect is also very important. You must know the legislative background behind all these rules and regulations. So theoretical aspect, you may have questions and case law based questions. Okay. And then this one I would like to highlight is you may have separate questions. Separate questions means in one question, you will have the question on Hindu law, and in another question, you will have question on Muslim law. That means they may be independent questions. But in some question papers of recent trend, you find that you can also have jumbled questions. Jumbled questions means, for example, question number 5 and part A. Part A will be inheritance. That is a question on succession to a male Hindu. And part B may consist a question succession inheritance to a Muslim, a male Muslim. So here Hindu law and a question on Hindu law and a question on Muslim law, they can be jumbled together, and you can also expect that type of pattern in your question paper. That means the very purpose of giving such a question with the jumbled laws, that is Hindu and Muslim law, is that there is a tendency among the students that they may eschew Muslim law totally and concentrate only on Hindu law, or they may do the other thing, that is reverse also. So, but basic understanding of both the law is essential, and your syllabus also contains only the fundamental aspects, and all the aspects of Hindu and Muslim law are not covered. So to that extent, every student must be well versed with the fundamentals of Muslim law and fundamentals of Hindu law. So that is the object behind giving a jumbled question also. So you have to be thorough. You cannot avoid, you cannot delete, because if you delete Muslim law of inheritance, then you may not be able to answer any 2-3 questions, because unless you have an answer for both Hindu law and Muslim law, you will not complete that answer. Or you cannot give a full answer and get 20 marks. Okay. So this is also one pattern. You be prepared for that also. Okay. So now a few theoretical questions. So I told you now a few theoretical questions. For example, the legislations which modified the Mitakshara co-parcenary and how it has modified. So the legislative history, you must know what are the legislations that have brought about important changes in the Mitakshara co-parcenary and how it has affected and what impact it has brought in. So there, generally, students, they forget to mention this Caste Disabilities Removal Act. So this is one thing that I wanted to highlight. You have to start from 1850 Caste Disabilities Removal Act, and it has the very important impact on the Mitakshara co-parcenary, because prior to 1850, a co-parcener who happened to be a Hindu, if he becomes a non-Hindu by way of conversion, he had to forfeit his property rights, either in the separate property or in the ancestral property. That was the law. But in 1850, this Caste Disabilities Removal Act was passed, which was otherwise known as Freedom of Religion Act, by which even if the co-parcener becomes a convert to non-Hindu religion, he will still have his rights, property rights. So the property rights are secured under this act. So this is one important change, initial change that has been brought about in Mitakshara co-parcener. Okay. So this you should not forget to mention. This is the starting point. Next. The next one is the most popular enactment, and this is Hindu Women's Right to Property Act 1937. And this is a benefit for the woman, female Hindu, who did not have any inheritance rights prior to 1937. And she was totally dependent on the husband's sapindas, that is the co-parceners, for her maintenance, etc. So for the first time in 1937, if the male Hindu died as an undivided member, then the property would not go back, would not devolve upon the surviving co-parceners. but the property, his share in the property would devolve upon his own widow. So that first inheritance rights was conferred upon the female Hindu under 1937, though it was a very major step in those days, but still it had certain limitations. And under this act, whatever that the property that was conferred on her, and she could enjoy the property, but she could not alienate it except for certain purposes. There were much limitations, and she could not give the property to her own children. Even after her death, the property would not be succeeded by her daughters, etc. So now, after her death, the property would go back to the surviving co-partners, who are called reversioners. So this system has been introduced under 1937. And so in the Mitaksha co-partnery, and this is one landmark legislation. Then after that, Hindu Succession Act, you all know, Section 14, this concept of limited estate has been expanded. And then Section 6, Notional Partition for the first time has been introduced. And if at all a male Hindu died without any partition, the law would presume that a partition had happened. So this is a formula has been worked out in order to see that the property of a male Hindu would be available under Hindu Succession Act. And Section 8, for the first time, females are introduced as class 1 heirs, and mother, daughter, and a widowed daughter-in-law. So there are many important changes that took place in the Mitaksha co-partnery. And so here, especially Section 6. Okay. So Hindu Succession Act. Next, state amendments. So for the first time, the joint family system, a focus was there on the joint family system, and Kerala has abolished it in 1976. And then for the first time in AP, followed by Tamil Nadu, Karnataka, and Maharashtra, in AP 1986, and Tamil Nadu 1989, Karnataka and Maharashtra in 1994, state amendments took place, wherein in the Mitaksha co-partnery, daughters, married, not married daughters, unmarried daughters were accepted as co-partners. So the co-partnery rights were given to unmarried daughters. So for the initially, the daughters, introduction of daughters into the co-partnery that has taken place under the state amendments, you must also mention this. And next, Hindu Succession Amendment Act 2005, all of you must be well aware of this act, where all India legislation in all India basis, the daughters, Hindu daughters have been made as a co-partners. So these are the important landmark legislative endeavors that has brought about change. So you please keep in mind. And next, under this, and there is one more thing, doctrine of pious obligation was also abolished under 2005 Amendment Act. So these are this doctrine of pious obligation is closely related to the co-partnery. So these are, so this is one type of theoretical question. You will get 20 marks. That is, it is for 20 marks. The full 20 marks question. Then praise the legislative endeavors to confer property rights to a Hindu woman. So here, out of these 5, from 2 to 5, and will be sufficient for you to give an answer for such a question. Then, what are the significant changes introduced in the Hindu Succession Act 1956 through 2005 amendment? Okay, and here you can find in 2005 amendment, the section 4.2 has been deleted, and we have cases in our case material relating to deletion of 4.2. Then section 6 has been recast. Their daughters are included as co-partners. And then enlargement of class 1 heirs. That means originally under 1956 Act, 12 class 1 heirs were there. Now it has been expanded to 16. So who are the class 1 heirs who have given more, that is rights in the succession? And then section 23 and 24 have been omitted. Section 23 has been omitted, where the right of the special rights of the daughters in the dwelling house. Earlier, she could not ask for partition till a partition has been made by the son and give the share to the daughter, that is his sister. And she only unmarried daughters had the residential rights. Married daughters did not have any residential right. And so these were certain disqualifications or limitations in the with regard to the dwelling house of the joint family or the dwelling house of the father. Even the father happens to be, the dwelling house happens to be the separate property of the father. And if he has son and daughter, and daughter's rights are limited under section 23. So this has been omitted. So by virtue of this omission, now daughters can equally claim a share in the interstate succession, okay, along with the son. Claim partition. So now section 24 is also omitted. It was a disqualification. Certain widows on remarriage would not inherit the property, but this omission has nothing. It has not made any impact. Even though section 24 has been omitted, the situation continues to be the same. The rule happens to be the same. So this is the difference between omission of 23 and omission of 24. Okay. And then section 30, that means the daughters, that is the female Hindu who have inherited, who have become a co-partner, they can also have the testamentary rights. Okay. So these are some theoretical questions that you can expect. Here and there you can just justify your answer with illustrations. Now, how to prepare for the exam? Okay. So now I have just given you an overview about the syllabus. And now, how to prepare for the case law based question. So now, read the case as per your preference. You can read the case, which case you want, that is, if it is a cup of your choice, and you can read that case first. You need not take up the case number 1 to case number 30. You can also pick and choose. So you take any one case, then ask yourself the introduction. What is the take home from that case? After just going through the case, what is that you get from that case? What is the information that you get? What is the knowledge that you get? What is the knowledge, how you apply the rule in that particular case? Okay. Now, whether a new rule has been evolved in that particular case, because I take you back to Hanuman Prasad case, Hanuman Prasad versus Musamad P.B case. So where a rule has been evolved with the Privy Council. It was a case decided by the Privy Council. I am just recollecting, refreshing your memory only. I am not telling any new thing. I am not teaching here. Okay. So now in this Hanuman Prasad case, a new rule has been evolved. That rule is the bona fide purchaser is protected. So that is the rule. A new rule has been evolved in Hanuman Prasad case. And in some cases, the rules have been clarified. Already they are rules, but there were some ambiguities in those rules. So the rules have been clarified. So if you just, I am giving an illustration, an example of Gurupad versus Hirabai, where section 6, how section 6 has been applied in the notional partition. So even in the notional partition, whenever partition takes place between the father and the sons, mother is entitled to a share. Okay. So that rule has been, already it has been there under the customary law and classical law, but there was some ambiguity with regard to notional partition, whether the rule will apply even to the notional partition. The court has said, it was a decision rendered by Supreme Court. It said, even in the notional partition, what are all the incidents of real partition should continue. So that rule has been clarified. So in each and every case, you will get that some rule has been applied, whether it is a new rule or there is a clarification with regard to an old. So this should be your approach. Then you have to come to the facts. In some judgments, you will have a systematic arrangement of facts, issues, and the arguments, etc. But in some judgments, you will find facts scattered here and there, or sometimes in the last para of the judgment also, you will find the facts. So now, unless and until you go through the entire case, you cannot assimilate the facts. So in my class, I usually ask the students to, I will be highlighting certain points, paragraphs where the facts will be there. Then I take them to the issue point, that is the second segment. And then the arguments from both the sides, the third aspect. And then the decision of the court, fourth aspect. That is how you have to go through the case, the judgment. So why the parties litigate? What are the bone of contention? Now, what is the legal issue in it? Every case will have some issue. Without issue, issue means the cause of action or why the case has come before the court of law. Okay, so why there is a difference of opinion on an issue. So now there may be difference in that is there may be a factual issue or legal issue, and legal issue is very, very important. Factual issues can be settled through evidences. Legal issues can be settled only through putting before the court the documents, etc., etc. All these things you have to look into. Then, what are the statutory provisions or rules or legal principles involved in that particular case? Whether it is section 14, 1 or 2, or whether it is section 15, 1 or 2, or whether it is section 6. So here you have to apply the statutory provisions also. That means you have to find out the statutory provisions involved in this particular case. Then, what the court has decided. So ultimately you must know, because some students, these are some common errors that we find through our experience, that the decisions will be misquoted, because the students sometimes they get confused with so many cases, and because of last moment preparation, maybe whatever may be the reason, they are not clear about the decision that has been rendered in that particular case. So I suggest that please don't misquote the decision. So decision should be you must be very, very clear what the decision happened to be. So whether it is favorable to this party or that party, whether whether the appeal was dismissed or appeal was maintainable. So all these aspects you should be very clear while looking into that case. Okay. So what is the decision? Now, you must not confine yourself to only the decision, but you must ask yourself why the court has arrived at that particular decision. Why not the alternatively? Okay. So here, what is the judicial reasoning? You have to find out the judicial reasoning, because in Chandrasen case, the judiciary has given some 5-6 reasons for declaring that any property, the separate property of the father inherited by the son will be his separate property, and his son cannot claim any share in that property. So this point has been highlighted. This is a changed rule from the classical rule, and this change has been brought about in Hindu Succession Act, and the court has taken clue from many provisions. What are those provisions? Because section 4 the court has highlighted, taken the clue. Section 19 the court has taken a clue, and section 8 the court has taken a clue. So all these reasons, all these things will come under the judicial reasoning, why the court was able to arrive at such a decision. So this is one important case that you can find out this aspect. Next, is there some important precedents that the court has discussed in that particular case? For example, in No Pani's case. No Pani case, you all know that whether in the presence of a senior karta, senior member, whether a junior can be a karta. So that was a case relating to No Pani's. So here in No Pani's case, the court has said already the case has been decided, settled by the Supreme Court in Tribhuvanda's case. So there the exceptions are there, that even in the presence of a senior male member as a karta, and a junior can also become a karta under certain exceptional circumstances. And the court has applied in No Pani's case whether this case will come under any of the exceptions that has been evolved in Tribhuvanda's case. So naturally, in No Pani's case, whenever you come, that is the No Pani's case come to your mind, and at the back side, you must also have the glimpse of Tribhuvanda's case also. It should also parallelly come to your mind. So certain important precedents are also there, and you must also be very well aware of those precedents. Okay. Then, and is there important hints to the legislature? So in that particular case, sometimes the court will just conclude with the judgment, that is the appellant has succeeded or the respondent has succeeded. But apart from that, some hints also the court will be giving to the legislature with regard to the drafting. So whether the provision has been well drafted or the provision needs some improvement. For example, in Tulasama versus Sesha Reddy, what is this case relating to? Under which topic the case comes? Under topic that is section 14. So limited estate. So under section 14 of Hindu Succession Act, the limited estate has been converted into absolute estate. So, but under section 14, clause 1, that is clause 1 is there, clause 2 is there. 14 clause 1, 14 clause 2. But there are certain overlappings in 14.1 and 14.2, which has created a lot of confusion and chaos. Many cases came before the courts and different verdicts have been given by different high courts. So in this case, in Tudasama versus Sesha Reddy, the Supreme Court has settled the point at rest, and it has highlighted that the legislature should have by this time, and it was a case in 1976, I think, because by 1956 to 1976, a lot of time has been that is lapsed. So the legislature must have by this time brought about an amendment in section 14 in order to make it so simple, and so that this much of time and energy has been wasted. The court has wasted this much of energy and time in order to settle the matter. So like that, the court sometimes also gives some hints to the legislature, and that also you must make an observation. So here in your semester 1 also, in Family 1 also, you have said that is whenever a case that is irretrievable breakdown of marriage comes, the court gives a hint to the legislature that it is high time that a provision should be made in that manner, or it is high time that uniform civil code must be in place. So all these are certain hints that is observations that are made by the court. So you see, if you just take a case and you have to find all these things, it is a small research. So each case study is a research on your part, and you can find all these things. And so here, whenever a case you have to study, you must know in total what is that case about, facts and issues and application of the statute, then what is the decision and what is the judicial reasoning behind the decision, and then precedents, and also any hints to the observations, court observation. So these are the things that you can, while revising, that is while making revision, you must see. Okay, I think by this time, at least 50% of the cases you must have revised and made it in this manner. Okay. So all this will give you some clarity. You need not worry that is, there will be a clarity. There will not be any confusion between one case and another case. So these are the advantages of making synopsis. Okay, next. You also find some groups of cases given in your case material. For example, if you take topic, yes, topic 4. So now in topic 4, the application of Hindu Succession Act, you have this Nirmala versus Government of NCT, Nirmala case, and then you also find Archana case. Both these cases, they speak on certain same issue. Similarly, there is one more topic, that is in topic 5, succession to the property of a male intestate, Gurupad versus Hirabai and Uttam versus Saubhag Singh. And next, similarly, you have in one topic, there are 3 cases, Ganduri Kotishwarama case, Prakash versus Polavati case, and Dhanamma versus Amar. Okay, these are the 3 cases. Why I have clubbed these 3 cases means all the 3 cases, they speak on, that is, the issue involved in these 3 cases are similar issues, but we find different approaches by the court in these cases. Okay. These approaches can be different alternative approach, or these approaches can also be contradicting approach also. So similarly, if you just look into this Karta's alienation, whether the Karta's alienation is perfectly valid or not, for what purpose he can alienate, so all these things. So there the Sunil Kumar case, Dev Kishan and Arvind versus Anna, all these are cases. That means you must, when you read one case and you just take up another case, you must know that this case is somewhere related to a previously read case. So that is how you can make a cluster of cases. So if you do this cluster, so you can have a comparative study. So for example, in Gurupad versus Hirabai, it is a perfect application of section 6 under Hindu Succession Act. But whereas in Uttam versus Saubhag Singh, the same Supreme Court, because these are the cases decided by the same court. So in Uttam case, that it is a peculiar case where it is a case of where you have to apply the notional partition, but that notional partition has been, that step has been skipped, and then directly in the undivided interest, suppose if the male Hindu died as an undivided member, leaving behind his heirs, for example, son, daughter, and there the Supreme Court has directly, it has applied Section 8, and it viewed it the property as separate property, even though it is crystal clear. It has mentioned in the judgment that it happens to be the ancestral property, co-parsonary property belonging to the joint family, and he died as an undivided member. But the court has lost sight of applying notional partition in this case. So it has got its own reason. So if you these two cases must have been completed in your case, that is in your class, to just revisit these two cases. So whenever a question is asked in Gurupad versus Hirabai, naturally you have to also mention this case also, and that is where you will be standing apart from the remaining students. So some originality, some hard work, it should be exhibited in your work, in your examination answer script. Okay, so that you must toil, or you must do certain exercises, you must work hard in order to see that your paper appears to be a unique paper and not a routine paper, and there you will score more numbers. Okay, so Gurupad, these are the two cases. And then Ganduri, Pulavati and Dhanama, it speaks about the prospective and retrospective effect of Section 6, very, very important. And in Prakash versus Pulavati case, it has been known as a settled case for the application of Section 6. That means Section 6 says daughters are co-partners. So from where, which daughters are to be co-partners? Here are the situations where in a family, the father must be alive as on the commencement of this 2005 Amendment Act, and the daughter must also be alive as on the commencement of this act. So these two conditions are necessary if the daughter wants to get a benefit of co-partnership rights. So that has been well established. It was a very logical decision. This is a Pulavati case, but whereas in Ganduri Kotiswarama and in Dhanama case, and especially in Ganduri Kotiswarama case, you may be, that is, I want to just recollect the facts. And she was a daughter, and the partition suit was there, already filed by the son. Now 2005 Amendment Act has come. That partition suit, in that partition suit, preliminary decree was passed. And so by when 2005 amendment came, she also claimed the reopening of partition, the daughter. And the court and the son said, already preliminary decree has been passed, there is no question of reopening. But the court held that even though a preliminary decree has been passed, still a final decree has not been passed, and the daughters have got every right to reopen the partition. So here the judgment went in favor of Ganduri Kotishwarma. But here this was a case decided prior to Pulavati case. So one important point has been lost sight of. Even the parties, they have not agitated, brought this in their arguments, that in this case the father had died prior to 2005. So only when Pulavati case has been decided, and this important fact has been missed out in Ganduri case. Okay. Then in Dhanama case, it is a mixture of Ganduri and Pulavati case, where the court has held that following Pulavati, that is, they said that the court has observed that in Pulavati case, the point has been settled, but it was a case where a partition suit was also pending. So in that case, when a partition suit is pending, the daughter has got every right to reopen the partition. Okay, but here also the father had died prior to commencement of this act. So here you will find some unique features in the judgments. Okay, some peculiar features in the judgment. And what are the peculiar reasons also? Because no judgment will be without any decision, any reasoning. And you must also have a chance, you will have a chance of looking at that reasoning also. So I have clubbed these three cases for a similar issue. Then Nirmala Archana case, whether agricultural lands are thrown open after 2005, whether agricultural lands are thrown open for the operation of Hindu Succession Act, to put it in simple manner, whether daughters can inherit to agricultural lands also post 2005, which was not available prior to 2005. In Nirmala case, the court, because these are the two cases decided by two high courts, In Nirmala case, it was decided by Delhi High Court. Archana case decided by Allahabad High Court. So in these two cases, the court has given a contradictory verdict. Here it said, Nirmala can inherit two agricultural lands. The impact of deletion of section 4 clause 2 is that agricultural lands are now open for Hindu Succession Act. But in Archana case, despite the omission of section 4.2, still the daughters cannot inherit to the agricultural lands because those agricultural lands, it has got certain constitutional perspective also. And these agricultural lands are created for certain purpose, and the state laws only will apply. Okay, here this is some difference between the Nirmala decision and Archana decision. So you must be very crystal clear where the courts have deviated, on what point it has deviated, and so this you have to understand. Then I have already discussed about this case. Okay. So why and how to prepare synopsis? So I have just, after reading all the cases, even while reading the cases, you have to take a A4 sheet paper. I have been telling my students that you have to simultaneously, you have to prepare the synopsis. You cannot first read all the cases, then you cannot go to prepare start synopsis. It should happen, both the things should happen simultaneously. So for example, if you have read Sujata Sharma versus Manu Gupta, so can you recollect the issue? And she happened to be the eldest daughter in the co-passionary. So the brothers, that is his father and the paternal uncles, after their death, she happened to be the eldest daughter of the eldest son. And so in the family, joint family property was there. She claimed to be a karta. So whether your daughter, for the first time, the case came before the court, and it was a case decided by the Delhi High Court. And so whether can eldest daughter act as karta post 2005, because one disqualification that she cannot be a co-pastor has been removed. Once she has been open, that is when the platform is open for her to step into the co-pastorary, then what prevents her from becoming a karta? So that has been highlighted in the particular case. And so here, by for and against arguments, you have to find out, and you have to make a column for the arguments also. Then you have to also give a column for decision. What is the decision? And here you must be very, very clear. Yes, she can act as karta. And reasoning and observation. And just I have put a question mark that you have to identify the reasoning and observation, because whether what is the purpose of this amendment 2005? That means in order to improve the status of the women, it is a social beneficial legislation. So we must give a beneficial approach to the issues. And so there are also certain constitutional provisions and international conventions that that is the daughter should also be given on par with the status, on par with sons. All these things have been highlighted by the court. You have to find the reason number 1, 2, 3, 4, 5, like that you have to write. Okay, this is how you have to prepare the synopsis. Okay, so now next Nirmala versus and next Archana versus. This is also whether the daughters get a share in agricultural lands pursuant to omission of section 4.2 of the Act. So the same issue has been raised here also, and the for and against are different, whereas the for and against are, because here the constitution, the parties have taken up the constitutional perspective is added to the facts of the case. And so in this case, the court said, yes, daughter is entitled to, but in this case, daughter is not entitled to. And Supreme Court has not, no case has come before the Supreme Court with regard to impact of section deletion of section 4.2. And so we find two different high courts decision. So what is the reason? Every high, that is here, it has given its own reasoning. It has also given its own reasoning. I think this might have been discussed in your classroom. Okay. Then. Yes. Why to browse the past question papers? So past question papers pursuant, that is pursue to obtain past question papers or previous question papers with a lot of difficult. Now it is available in DU website, but earlier the past question papers or the old question papers, they are not easily available. and they may be available in the Dukis, but it is worth pursuing these past question papers because you will identify the repeated questions, because in every subject we find that every student will be examined on the fundamental aspects. Okay, so those questions which will examine the fundamental aspects of the knowledge and application domain of the students, and they will be often repeated in the every question paper. So you will find what are the questions that are repeated in the old question papers. For example, there is no question paper without notional partition. There is no question paper without succession to a male Hindu. How you will apply the law to the male Hindu? You have to learn. And there is no question paper without a question having who will succeed to the female Hindu if she dies, leaving behind certain heirs and leaving behind certain properties. And next, inheritance to a male Muslim, inheritance to a female Muslim, and the validity of a hiba, the three essential features of hiba. Next, separate, what are the separate properties? What are the joint family properties? Because the basic difference is in the separate properties, sons cannot ask for share. In the joint family properties, sons can ask for share. And all those cases, no, Arunachal Mudaliyar versus Muruganath Mudaliyar, Chandrasenka case, all these cases come under this category. So now, validity of Karta's alienation. So Karta has alienated these many properties which he has acquired, and 1, 2, 3, 4, 5, and then the sons want to challenge the alienation, whether it is for legal necessity or it is for benefit, whether there is a question of legal necessity, whether the marriage of a minor daughter is a legal necessity or not. All these aspects are given in the old question paper. They are quite often repeated. Okay. So that is why if you just browse the question papers, old question papers, you yourself will know what are the important questions, and you need not ask the teachers, madam, please provide us important questions. Okay, you yourself can identify the important questions. Okay, for a teacher, each and every question is an important question. Okay, now the next thing is to know how they were asked in a different manner. So here, even though they are repeated questions, and you will not find them in the similar tone, and they will be asked in a different manner. So what are the various alternatives in which alternative that the question has been set, we will also understand. So that means all these things will give you enough confidence to answer your real question paper. Okay. And to see various situations possibly can be inserted in the questions to test your knowledge. For example, if I take an example of notional partition case. So you must know the rule between the rule among the Dravida school and non-Dravida school in the case of notional partition. So in case of notional partition, or in a case of any partition between the father and the son, if the family belongs to non-Dravida school, mother is entitled to a share. And in the case of Dravida school, mother is not entitled to a share. This rule you must be aware in order to apply your knowledge to the given question. So in some cases, the case will be on Dravida, and in some cases, in question, the case will be on non-Dravida. Next, pre and post 2005 law. So prior to 2005, daughters are not included as co-partners. You cannot add them into the notional partition. But post 2005, the sisters and the daughters must be given a share in the co-partner. So this rule you must know. Next, individual and collective shares to women at the time of partition. So in the case of notional partition or the time of partition, father has his widow. That is the person, for example, a Hindu died as an undivided member, having his mother and father's widow. So mother means his own biological mother, father's widow means a stepmother. So in the notional partition, mother as well as the stepmother are entitled to a share, and how much share each is entitled, whether they will take collectively or they will take individually, you must know the rule. And they will take collectively at the time of partition. And now, one more aspect is what is the status of separated son? And this is also, there will be a confusion among some students. That is, whether he will participate in the notional partition. You all know it is very much sure that he will not participate in the notional partition. But in the case of intestacy, whether he will participate, according to old law, he will not participate. He was not entitled to participate, but according to 2005 Amendment Act, Section 6, if you just go to the Section 6, there the separated son will participate in the intestacy. That is the last round of partition. So this rule you must be very, very clear. So these are the rules that you must have clarity. So in order to judge your knowledge, so many various situations, you cannot expect that all the situations are present in one single case. In one question paper, and one aspect will be asked, and in another question paper, another aspect will be asked. So that is the benefit of going through many question papers. Next, status of illegitimate children and illegitimate children of legitimate predeceased children. And you must be knowing the difference. The status of illegitimate children, they will inherit to the mother but not to the father. And even to the father, the illegitimate children of legitimate predeceased children, they are not class 1 heirs. Okay. Now, disqualification of remarriage, conversion, and murder. And murder of the proposed, conversion, converted heir is not disqualified. That converts descendants are disqualified. And there is no change in the position of remarriage of the widow. And once she remarried, she will not inherit any property in the father-in-law. Okay. And then certain cases, the properties which will come under 15.1 or 15.2 in the case of in succession to a female Hindu, and in case of limited estate converted into a absolute estate, some properties will come under 14.1, some properties will come under 14.2. So what is the criteria behind this distinction between 14.1 and 14.2? So here also you must know the rule. And then status of sharers. And if you just go to Muslim law, similarly, you must be knowing the status of the sharers. How many sharers are there under Hanafi system? 12. And among 12, 5 are primary shares, and they will never be excluded. And then residuary. Son is a residuary, you must be knowing. So whatever that is remaining, he will get. And daughter will become a residuary along with the son. So once she becomes a residuary and original position happens to be a sharer, but if there is a son, then she will also become a residuary, but she will not take equal share along with her son. She will take half the share of the son. So you have to take a ratio of 2:1. Son and daughter is equal to 2:1. So these are the things that you might have learned. Okay. So under changed circumstances, their shares will be changed. Mother share also will be changed under different situations. When there is a child and when there is no child, generally when there is no child, the share is increased to double and all these things. And then restrictions on the testamentary power of Muslim. So you must be knowing the testamentary power of Muslim is not absolute. He cannot bequeath more than 1/3 of his property, and he cannot also bequeath to the heirs. So with regard to heirs, and the consent of other heirs is required in case of Sunnis, and the consent of other heirs is not required in the case of Shias if they take within bequeathable. Okay. So this bequeathable 1/3 principle you must be knowing. Next, abatement of legacies under Sunni and Shia law, the rules that are applied followed by them. So I have given an overall picture of these are the various nuances of family law too. Okay. And you must be very clear about these rules and regulations. Okay. So once you know all the rules and regulations, it is very, very easy for you to complete your answer within minutes. Okay. So this is one. And then now going to why you have to browse the old question papers. After taking one question paper, you will try to attempt all the questions. Then you will have a self-check of your understanding. So where are the points that you don't understand? You will once again open the book, revise it, and then re-attempt it. So it will have a self-check of your understanding of your family law too. And whether you need another revision or not, that you yourself will judge. And then probable future performance. And by evaluating one question paper, by attempting one question paper on hand, and you will also predict that how you will perform in your real question paper. So this is also one important, it is a sort of confidence boosting technique. And if you revise old question papers, then, and there are 5 question papers, I think 5-6 question papers available in the DU website. Okay, and they are also available among the students. And if you don't, if anybody doesn't have, you can just request your classmate and to share it. Okay, and then, and what you should do after revising the question papers, you have to prepare the synopsis and practice writing the answers in an organized manner, because nowadays the skill of writing, it is going to eclipse. That means we are very fond of listening, we are very fond of reading and having a glimpse at that thing that is there in the screen. But actually, if we want to write and we feel lethargic and we feel lazy, so the skill of writing, when we lose touch of writing habit, and suddenly if you go and sit in the examination hall and start writing, and you cannot put the answer in an organized manner, and there many students, they are not able to manage the time, and they will be scratching, that is they will be attempting one question, then striking it, and then attempting another question, then also striking it. So wastage of time and energy, and at last will lose the confidence. So all these things can be avoided if you practice writing the answers. Okay, so once you start writing at home, then all the initial hiccups will come to light, and then you yourself will know where you stand. Nobody need to assess you. You yourself can assess your capacity and caliber. So now, how to answer the questions involving calculation. So the theory questions you can answer, and certain questions involving calculation, because family law too, many students, they fear, they have an apprehension that all these fractions very difficult, it is very complex, we cannot add, we cannot subtract, everything. So but when you just know the mathematics, the fundamentals of basic fractions, okay, then it is a very easy one. And if you attempt the questions involving calculations, out of 20 you will get 20. And this is the difference between or advantage of attempting a calculation based question rather than a theory based question. Whatever you write in the theory, and 15, 16, that will be the thing out of 20. But the number that you can get, if it is the math, it is like mathematics, isn't it? If your steps are clear, and if your explanation to each and every rule is clear, and if your answer is clear, then there is no scope for the examiner to deduct any mark. So you will be getting 20 out of 20 or 10 out of 20, 10 out of 10. So this is one advantage, but you have to practice. Cases on notional partition and interstress. So I have taken one notional partition because here this is one area where the students, and how many times we explain and how many times you people do it, still you will find some clarity. Okay, wanting clarity. I have given this illustration. Yes, it is not a complete question, but I want to highlight certain important aspects. Okay. X, a male Hindu, died in Delhi as an undivided member of Mitaksha Co-Partnery in 2007 and was survived by parents M and F, stepmother SM, married sister SI, widow W, sons S1 and S2, and daughter D. S2 has separated from X in 2006. Distribute the property. Here you see, in one question, I have given you various combinations, that is various nuances of this notional partition. Now I have highlighted in Delhi, the place is there. That means the school belongs to non-Dravida school. Please close your video. and he died as an undivided. So sometimes students get confusion whether it is a question coming under section 6 or question coming under section 8. So sometimes in notional partition, so I request the moderator.
Yes, ma'am. Tell me.
Yeah, please ask the participants to close their videos. Yeah, or you yourself can also.
Video.
Yeah. Some participants, they are coming in, sharing the slides. Please
Okay,
take
ma'am.
care. Yeah.
Yes.
Yeah. So
Please,
now,
yes.
So undivided member. So the clue that is given as undivided member is that you cannot go without applying section 6. So when you find in this question as undivided member, this is a question relating to notional partition. It is not a question relating to exclusively on interstate succession. Okay. And next, of Mitakshara Gopasnari in 2007. So this year is also very, very important. And it is whether the case comes prior to 2005 or post 2005, where the daughters must also be included. You must take care of that aspect also. And he was survived by mother and father, stepmother. So here notional partition may, stepmother also is entitled to a share, but individual share to mother and the stepmother, not they will take collectively. Then married sister. So sister is also a daughter of that family. And since it is 2005, post 2005, sister will be included in the notional partition, but the marital status is irrelevant. Only in state amendments, the marital status was very much relevant, but in Central Act, it is irrelevant. Widow, and it is clear, son 1 and son 2 clear, daughter is also clear. So now in the son 2 has separated. So it is a status of separated son. I am once again repeating these, what we can say. These are certain important points that you have to take note of it while penning down your answer. So now in this case, I am not giving you the answer, but I am asking you to take a note of how many notional partitions involved in this case. In some cases, there will be 2 notional partitions and 1 interstate division. And in some cases, there will be only 1 notional partition and 1 interstate division. So it depends on the generations that you find in that case. Here, this Hindu died, not leaving behind only his son, but he has left behind his father also. So it is a 3-generation people that you find. So when there is a 3-generation people living, cited in this case, 2 notional partitions will be there. 1 notional partition is between X, his father, and his married sister, 1/3. But the share, that is whenever a partition is made and a mother and stepmother are entitled, that means 1/5 each will get. So in the first notional round of partition, it is a big partition, and the second notional partition, and his 1/5 will devolve upon his son and daughter. And whenever a partition between his son and the father take place, widow is entitled to a share. So 1/5 divided by widow S1 and daughter, that means 1/5 divided by 4, 1/20. You cannot give S2 any share in the notional partition. So 120 is his separate property, and this is how you have formed, that is you have applied the formula of section 6 and you have converted his undivided share into a divided share. That is to be available for section 8 to apply. So this 1/20 of X, that will be available to class 1 heirs as per section 8. So class 1 heirs are mother, class 1 heir, and now S1, S2, daughter, and or class 1 heirs, widow. So now W, S1, S2, daughter, and mother. 5. So 120, 1 by 20 divided by 5, 1 by 100. So this is how you must work out the problem. So how many notional partitions? 2 notional partitions. And 2 notional partitions. And relevancy of school is important. Relevancy of year is also important. Relevancy of marital status, it is irrelevant. Shares of mother and stepmother in notional partition, individually you have to give. And status of separated son to participate in the notional partition and intestacy. So post 2005, there is only single disqualification. Pre 2005, 2 disqualification. He could neither participate in notional partition nor in intestacy. But in post 2005, he will be given as a class 1 heir. Nothing prevents him to get a share in the intestacy, but he will not get any share in the notional partition. Okay, then you can clearly represent it through a table and correct calculation in each step, and you can expect the full number 20 for this. Okay, next question on section 8. X, a male Hindu, died intestate. So this is the difference that you will find. If he died as an undivided member, go to section 6. If you died as an intestate, it is a clue that you have to directly apply section 8. Okay. In 1994, and left behind father, mother, W, S1, S2, S3, D1 and D2. S1 during the lifetime of X had converted. So this disqualification is entering into this question. What is your knowledge and how do you deal with this? Next, S2 convicted for murdering ex-brother. So murderer, what's the disqualification relating to murderer? And S3 is an illegitimate son. What is the rule relating to illegitimate son? To inherit to the male Hindu. Okay, where we are looking into the succession to a male Hindu, not to a female Hindu. So whether he will be given a share. Then D2 married a Christian under Special Marriage Act. Whether her marriage with a Christian has anything to do with her inheritance rights? No. Next, the property of X was worth 20 lakhs. So here the monetary value is also given. So the examiner expects you to proceed further after working out the shares. You have to convert those shares into money. So that you must be knowing. So in order to test your knowledge, this money value of the property is also given. So now ascertain the shares of aforesaid heirs in the X property. So now I have already given you. Convert is not a disqualified heir. And murderer of the propositors is only disqualified, but he is not the murderer of the propositors. He murdered some ex-brother. So he is also not disqualified. S3 is disqualified. D2 is not disqualified. And D1 is also qualified. So here, except S3, all people will inherit. Okay. But their inheritance should be converted into money. So now, legal status of each person mentioned in the problem must be explained. So your role starts that. Why you are giving, here you see F. F is disqualified because F is not a class 1 heir. Mother is a class 1 heir. In the presence of class 1 heir, class 2 heirs will not inherit. Father is a class 2 heir. So you must say F. Since he is a class 2 heir, even though he stands in entry 1 and he will not inherit. Mother, she is a class 1 heir, she will inherit. W, she is a class 1 heir, she will inherit. S1, and he has converted, but as per that provision of the act, convert is not disqualified. Okay. So like that, the legal status of each person mentioned in the problem must be explained, whether they are qualified or not, why, rules involved to be explained, clear representation through the table you can make it, and correct calculation in each step, and then answer in money value if asked. So then you will get full marks. Full number you will get. There is no scope for the examiner to cut any mark. Your answer should be such that. Next, Remember other important distinctions since the time. Yes, I am hurrying. So properties coming under 15.1 and 15.2. Yeah, moderator, can I just take 5 minutes?
Yes, ma'am, no problem. Then after that,
yeah.
Yes.
Yeah. Properties coming under 15.1 and 15.2. So you must know what are the various kinds of properties in the hands of a female Hindu, and she can have separate property. She can have inherited property from her parents or from her husband, or she can also be as a co-partner. She could have some co-partnery property. So now her status, that is the inheritance to her property, depends on whether she died without any child or she died with child. So if she died having a child, you just simply forget the source of the property. So all properties will come under 15.1. 15.1 A, B, C, D, E options are there. So here 15.1 A, or in the absence of 15.1 A, it will come to 15.1 B. So if she has a child, then it makes a lot of difference. But if she doesn't have a child, then the law says you please go to 15.2. So if she has inherited from her parents, and that will go to the heirs of the father. If she had inherited from her husband, that the heirs of the husband will take the property. But the point that you have to observe is 15.2 does not have one more clause. If she died without any child, having separate property, okay, there is no mention in 15.2. So since 15.2 is very closed one, and whatever that doesn't come under 15.2, you have to bring it under 15.1 naturally. So if it is a separate property, whether she has a child or she doesn't have a child, then 15.1 alone will take place, will govern the situation. Okay. So these are certain differences that you have to look into while deciding the cases under 15.1 and 15.2. Then property acquired as a co-partner. So this is one thing. It is only 2000, post 2005, this dilemma has come, whether it is inherited property or her separate property. It is neither inherited property or nor self-acquired property. It is a category in between. So whatever property she acquired as a co-partner, that also depends on who will inherit, will also depends on whether she died as an unmarried daughter or died as a married daughter. If she died as an unmarried daughter, then the property would revert back to the father's heirs. That means they're surviving co-partners. Okay. If she died as a married daughter having a child, then 15.1 will take place. Okay. If she died as a married daughter and she had asked for partition, she got her co-partner property, but she died without leaving a child, but having a husband. Whether husband would take the property because the property belongs to her natal family. So there is a dilemma, and generally it is said that the property would revert back to, the judicial decisions say that the property would revert back to the source. That means the father's heirs or the father's family. So these are certain nuances and some small, that is some what we can say minute details that you must be knowing. And then rules regarding a female leaving no child, yes, dying as married, everything is there. Then properties coming under section 14.1 and 14.2, and the case, the underlying criteria for the distinction, and Tulasamma versus Sesha Reddy, you have to go through this case if you want to understand. So any right, that is any property that a female Hindu acquired for maintenance, in lieu of maintenance, where there is a pre-existing right, as a matter of right, she can claim that property, and that comes under 14.1. And if she has got any limited estate by way of charity or by way of grant, and then the testator's freedom to testate the property should be honored, and that will come under 14.2. That means limited estate concept has not been fully abolished, and 14.2 is still there, and 14.1 will be applicable only where the property has some link with pre-existing right. Okay, so this is the difference between 14.1 and 14.2. I think you must have heard the lectures from your concerned teacher, and Tulasamma versus Sesha Reddy is the case. Okay, then. So keynotes on Muslim law. I don't want to take a detailed session. And HIBA, it is very, very easy. HIBA, the general rules, and more than the general rules, you just concentrate on the exceptions. So acceptance must be through the guardian, okay, by the natural guardian. In case of the donee happens to be the minor, the guardian must be the acceptor. So who is the guardian under Muslim law? Father, father's father. So whether mother can accept on behalf of the minor. So it comes under the exception, and you can just go to Katisa Uma case. It is a similar case of Gita Hariharan case, and I always find a similar Supreme Court tone also in these two cases. So under exceptional circumstances, mother can also act as a guardian to accept. So exception, you just go to the exception, and the cases are there in the exception also. So you have to write with supporting cases. Then wasiyat. So if you just look into the testament of a Muslim, you just concentrate on restrictions on the testamentary power. So there are two restrictions. One is to whom he can bequeath the property. That means he cannot bequeath the property to a heir. There are certain conditions and ifs and buts are there. And he cannot bequeath some property in favor of some institution which is opposed to Islam. So these are certain restrictions on the testamentary power. He cannot bequeath his total property. He can bequeath only 1/3 property. And all these restrictions, you just focus on this. So the general power and the restrictions are there. But how these restrictions under exceptional circumstances need not be followed. Okay, that also you just look into. Next. In wasiyat also, abatement of legacy is one important thing. And this is very easy if you just understand the basic principle. It is very easy, and within 4 minutes you can score 20 marks. Okay. And in abatement of legacy, there are two situations are there. And the first situation, when the bequest to each legatee is different, 30,000, 40,000 and 50,000. That. The second situation, when the bequest to each legatee is equal to 1/3 asset. That means if the total asset is 90,000, bequeathable 1/3 is 30,000, and the Muslim wants to give property to A, B, C, 30, 30, 30, and each legatee is equal to 1/3 asset. Okay, this is the second situation. So there is different principle adopted by Sunnis and Shias. Sunnis adopt the rateable distribution. That means you have to make a ratio of A, B, and C, the legatees. Then you have to divide the ratio according from the divided by the bequeathable 1/3. And then what about the Shia? And chronological preference. If 3 persons are mentioned, or 3 wills or separate wills are also there, the first one will have a preference. So X, Y, Z. So X will have preference. And then if something is left, Y will get. And if something is left, then Z will get. That is chronological preference. And in situation 1. In situation 2 also, there is no difference. That is, there is no difference in the Sunnis. And even in situation 2, the Sunnis follow the same principle. That is rateable distribution. There also you have to find the ratio 1:1:1. Then you have to divide it. But in the case of Shia, there is a unique thing that you will find. The chronological preference will be followed in the reverse order. So if there are 3 legatees, X, Y, Z, and first Z will get something, and after that Y and X will not get. So here it is counting from the reverse side. That means the last mentioned will get the first preference. So these are the things I want to just refresh your mind, because you maybe I am going under the presumption. Initial stage also I have told you that you have already revised, and only I want to recollect and highlight the important aspects. Okay. Next, inheritance under Hanafi law, single scheme of succession to males and females, unless Hindu Succession Act. You need not worry about the reversionary. You need not worry about the joint family property, whether it is separate property, ancestor property. All these things are not there. And there is no different scheme of succession. Only same scheme of succession to males and females are there. And then source of acquisition of property is irrelevant for both and male and female. So for example, the female, and whether she has inherited property or whether it is a separate property, doesn't matter. The same rule will apply. So now you must know who are the sharers. 12 sharers are there. and even for your examination point of view, and focus on 5 sharers. That is, first 5 sharers, husband, wife, daughter, mother and father, and who are the sharers, how much is their normal share, under what conditions it will change. It is also problem based question, and if you understand the rule, and you will get sent up. And then status of the daughter as sharer or as a residuary, I have already given you an illustration, and in what ratio she will share with son, how to calculate the fractions. So you have to do a lot of exercises. I have just given you one illustration. It is a case of male Muslim having 2 wives. So 2 wives will take collectively, and then he has S1, S2 and daughter. So daughter is not a sharer, and daughter is a residuary along with the sons. So, but after becoming a residuary, she will get only 1 share, sons will get 2 shares. So 2:2:1. So now W1 and W2 take collectively 1/8. And 1/8, if you want, still you want to divide, you can give 1/16 to W1, 1/16 to W2. And then in the rule position, I have highlighted, in the presence of sons, daughter becomes residuary. And you have to find out, because here you see, the students, they will forget about this step. Okay. So they will say W1, W2, 1/8, and son 1 and son 2, they will take half, that is 2 shares, and daughter will take 1 share. But that is not the complete answer. You have to find out the residue, and in the residue 7/8, S1 and S2 and D will take 2:2:1. That means in the fraction of 2/5, 2/5 to 1/5, son 1 residue may 2/5, son 2 the same residue may, he will get 2/5, and in the residue daughter will get only 1/5. So in every calculation, the last step that I advise for every student is, you please cross check. You have to cross check. If you cross check, then if you get the number as 1, that means you have never committed any error and your calculation is perfectly correct. So here, if you cross check, this 1/8 plus 14/40 plus 14/40 plus 7/40, and you will get 40/40, that is 1. That means you have done the exercise, that is, you have distributed the property in a correct manner according to the last slide. Do's and don'ts. I am not here to preach, but still, I would like to just highlight these do's, which will enable you to perform better. Organize your answers by practice. Don't enter the examination hall without previous paperwork. Okay. So you will be feeling very much, that is, you will not be in a position to organize your answer. Okay. So practice it. Use diagrams and flowchart that will be self-explaining, and explain the facts with flowchart, and select the correct choice of the question. This is a general one, and as an experienced examinee, and you may be having your own idea what is the correct choice of question. If you have a good study partner, and that also it is a general instruction, and then attempt 100%, plan your exam day. So this is on family law 2, specific do's are: use diagrams and flowchart, explain the facts with flowchart. Okay, so that will get you more marks. Then don't give fictitious cases, because some students, they will be giving some cases, the names are unknown, that is not heard. So don't give any fictitious case, and don't say that in a landmark case. In a landmark case, what is that landmark case? At least you must have half title. For example, Prakash versus Pulavati case. At least you can write in Pulavati's case. Even if you don't know the other side, you have to mention at least one party's name. So, and you cannot say that in a landmark case it has happened. In a landmark case, the court has decided. What is that landmark case? Okay. So all these practices you try to avoid, and then don't give fictitious names also. And then, for example, in topics 2 and 3, don't give general analysis first and very short answers in the end as valid or invalid. For example, and 4 questions. So these are the alienations made by the karta, and what are the valid alienations, etc. So some students, they have the habit of giving a long essay on the topic. Karta, his alienatory powers, what are the benefits of a state, what is the legal necessity, everything. At the end, number 1, valid. Number 2, invalid. Number 3, valid, like that. So that is not the correct way of answering the question, and each question needs separate explanation followed by answer. So I think you may understand, because I'm just explaining it orally and I'm not able to put it in writing. So you try to understand this, okay? And then do not attempt complex questions unless you are thorough with steps and calculations. So sometimes while reading the question, you may be ambiguities in many areas, and you may also not know the correct position of law. So you keep it, you defer it, and then you can think and write it, okay? So that is one thing. Do not give general analysis unsupported by cases. Some students, and in some answer script, generally we find that not a single case is quoted by the student. Everything is general analysis. It is a layman's analysis. And in general knowledge, applying the general knowledge, the questions are answered. So the examiner doesn't get satisfied, because what is the fun of having this case material with 30 cases? Not a single case is quoted by a student in any question as an answer. So that will not, that is even, that will reflect on your, that is the preparation. And so you should not do it. Don't give general analysis. And in every case, at least you have to substantiate it with your illustration or with the example or with cases. Okay. So that you have to do. And then don't do the postmortem of your performance. Once you have given the exam, then don't worry about it. Then just move towards the next destination, and whether this answer is correct, or whether I have made a calculation the right way or wrong way. So it will pull you down, and it will also prevent you from furthering to your next paper. So never do this postmortem of your examination performance. Once it is given, it is given. Okay. And then you just look forward for the next paper. So these are certain few guidelines, my dear students, and all the best. And thank you for patient hearing. Thank you for the moderator. Thank you for the organizer for giving me this opportunity to meet all the students on a common platform. It is also a rare experience for me, a good experience for me. And I cherish this experience. And thank you very much. All the best for the students, all the students. I express my best wishes for your performance in your examinations, and all the best. Everyone should get above 60. That is my wish. Okay, thank you.
All right, ma'am. Thank you so much for structuring everything in such a professional manner. And I'm sure this will be a huge learning for us. And you made us focus on the important cases, went through the syllabus.
One second, I will just PPT, I will unshare the PPT, and then I can look into. Yeah.
Yes, ma'am.
Yes, please. Yeah. Am I visible? Am I visible?
Yes, absolutely.
Okay. I am visible to the participants.
Yes, ma'am, you are visible.
Okay. Okay, ma'am. Okay.
Yes, ma'am. So thank you so much for focusing on the important cases, going through the syllabus and comparing the cases with the same issues, and preparing how to prepare a synopsis, which stated the case facts, the arguments, the decisions, and the reasoning and observation. Then you talked about the past question papers and how to go about it, and observe and answering the questions as well. So, ma'am, would you like to clarify about the omitted cases, as there is some confusion regarding the same amongst the participants?
Yes.
And the omitted topics as well.
Yeah. Actually, originally, some days back, a first meeting happened on the instruction of Dean. that we have to make a subject meeting and to discuss about the coverage. Actually, at that time, we were not aware when this corona lockdown will end. So when the classes will be restored or not, all these things were there. So there was a presumption that because the students are not, because all the students may not be having the technology support, even if we take online classes, they will not be in a position to access them because they may be in remote areas. So all these considerations made us to delete certain topics. So according to convener's guidance, and we have announced the students also, we are also asked to announce the students that certain topics have been deleted, especially section 14 is deleted. And then Muslim law of inheritance, because it needs blackboard. If there is a blackboard, it will be very easy to make the students understand. It is full of calculations, isn't it? So on that basis, these two topics have been omitted. This has been informed to the students, and then some new cases, the new cases added. So that has been omitted. But later on, another instruction came from Dean that as per the Bar Council mandate or instructions, whatever may be, and all the portions should be completed. And no topic is to be deleted, no topic is to be omitted. So the entire syllabus is to be covered. So again, we had to revisit our plan. And so we are asked to give the information to all the sections, to the concerned section, the concerned teacher, that please inform them that there is no omission of cases, there is no omission of topic. So that is why in my slide also, in the second slide, I think, and all the 10 topics I have covered. Yes.
Right.
So there is no omission. There is no omission as such. Yeah.
What everyone was hoping for.
Yeah, it was a very, even the students, they were very glad because these are some complicated or we can say comparatively difficult topics. Okay, Muslim law of inheritance. But later on, because there is no time, that means the exams days have not been announced. So there is a lot of time for us to teach. So they said, let us complete. So accordingly, I started completing all the syllabus to my sections. So I shared the notes. I have given the PPT presentations for all the topics. And I hope every teacher must have done it. Okay.
Yes, ma'am.
But from examination point of view, all these are there are certain repeated questions, and even Muslim law of inheritance, which has been first omitted and later on included. It is very easy if they concentrate. That means if they give some time, at least 2 hours, they can sit, take a textbook and just work out some basic, because the questions will not be so complicated. The questions will not far fetch away from the sharers. Okay, so let them concentrate up to the sharers. That is, what are their sharers, especially the mother share, daughter share, etc., etc., and that will be useful for them.
Yes, ma'am. So definitely.
Yeah.
So moving on, we now would like to take some questions from the participants.
Yeah.
Yes. So
Yes.
I'll read it out as it is. And so here it says that what are the years in which unmarried daughter considered as co-partners in Kerala, Tamil Nadu, Maharashtra, etc.?
Yeah. So in Kerala state amendment is different. Right. There are 5 state amendments. One is Kerala, Andhra Pradesh, Tamil Nadu, Karnataka, and Maharashtra. Kerala, the joint family system has been abolished. Whether it is a patriarchal joint family or matriarchal family, it is abolished. So there is no concept of co-partnery, and there is no question of considering daughters as co-partners, because the very foundation of the joint family and co-partnery, on which the daughters are included, it has been abolished even way back in 1976. Okay. So there is no joint family system in Kerala among the Hindus. Okay. And remaining 4 state amendments, that is Andhra Pradesh state amendment, and for the first time it has taken an initiative, and in 1986. Okay. and the daughters, unmarried daughters, were included as co-partners from 1986. And in the Bar Act itself, you will find all the state amendments also at that is in the relevant place. For example, they have inserted section 29 ABC. After 29 section, you will find Andhra Pradesh amendment, Tamil Nadu amendment. Okay, and you can just look into the Bar Act also. And so in 1986, and Andhra Pradesh has introduced, it has thrown open the co-partnership to unmarried daughters. And in 1989, Tamil Nadu did it. And in 1994, Karnataka and Maharashtra, they have thrown open the co-partnership for the unmarried daughters. These are the relevant years. Yes.
Right, ma'am. So, ma'am, next question is that question this question is related to section 15 of the Hindu Succession Act.
Yes.
And a Hindu female died intestate, survived by a husband and a son. Property of that woman in question was inherited by her from her father after her death, where the conditions of section 15 clause 1 or 15 clause 2 will apply. That is where the husband will inherit half of share as per 15 clause 1a, or only son will inherit the property. Courts have mixed opinion on this. Would you like to say something?
Yes, it is a very clear case. It is a clear case. There is no scope for any ambiguity, because if there is a child, if she dies with a child, okay, and then there is no question of the source of the property. Whether she has inherited the property, or whether she has acquired the property, or whether it is a separate property, as long as the son is there, child is there, or the children of predeceased children, and along with the son, the husband is also entitled to a share. So husband will be always a beneficiary if there is a child existing. So whatever may be the property, not to worry about the source of the property as long as the child is there. So in the given case, 50% will be taken by her husband and 50% to the son, irrespective of the fact that she had inherited the property from her father. 15(1) is a clear application.
Right, ma'am.
Yes.
Absolutely. Yes. So, ma'am, the next question here is that it's related to co-partnership property. After passing of Hindu Succession Act, the character of separate property inherited by heirs remains separate, which was major deviation from classical law. Also, doctrine of survivorship was diluted and later removed in 2005 by the provision of National Partition. Now, in the case of Uttam versus Saubhag Singh, court accepting the nature of property as joint family property still considered it absolutely owned by grandfather. And on his death, it would devolve to his heirs by Section 8 and not Section 6. Thus, court completely changed the character and of the property and neglected the provisions of Section 6.
Yes.
So can this judgment be considered a stepping stone towards further dilution of co-partnership property?
So, the relevancy of judgments, okay,
right,
how far it can act as a precedent, we have to see. So in subsequent cases, on a similar situation, if the Supreme Court, the apex court, takes it as a precedent, the Uttam Singh case as a precedent, by giving some hint to the legislature, okay, because ultimately, whatever change it is to be brought about in the law, the legislature is the authority, and the judges cannot undo the law, the judges cannot modify the law, as long as the law is clear, and the judges cannot undo the law. So here, unless and until it becomes a precedent in subsequent cases, it may be a forerunner for the law to be changed by the legislature, by the parliament. It has got only a precedential value. That's all. And it is a clear deviation from Gurupad's case. It is a clear deviation from the well-established principle. Yes. And in your question, the first part, can you repeat the first part in your question?
Yes, ma'am. So, ma'am, in the case, the court accepting the nature of the property as joint family property.
No. You just go further back.
Okay.
The change, classical law. There is a
Yes,
change.
yes.
Yeah.
Yes. So, ma'am, after passing of the Hindu Succession Act, the character of separate property inherited by heirs remains separate, which was major deviation from classical law.
Yeah, this you are clear. The students are clear because according to classical law, if the ancestral property in the hands of the father falls on the son, it is the ancestral property. If the separate property of the father devolves on the son, that also considered to be ancestral property. So any property which a son acquired from the father, whether it happened to be ancestral property or separate property, because he acquired from the paternal ancestor, it was considered as ancestral property. This was a classical rule. Okay. In Chandrasenka case, the court said, by introduction of section 6 and section 8, okay, this classical law has been changed. So now, ancestral property will come into the hands of the son as an ancestral property. The separate property of the father will come to the hands of the son as a separate property. So this is the difference between classical law and Hindu law. This fact has been highlighted in Chandrasenka case. So I request the students to go that part. Okay, that is. Then you have asked that Uttam Sinha case. So Uttam Sinha case, it is a question to a judgment to be commented upon. There are certain fair comments also. Excuse me. So it is a deviation, but once the deviation becomes a precedent, okay, then we have to wait and see.
Right. So, ma'am, moving on to the next question and the last for the day. We have property owned by father in copartnery. A father dies in 2002, and as per Section 6, National Partition is considered. Now, the share of the three sons, that is S1, S2, S3, is 1/4 by the way of partition, Section 6, and 1/12 by way of Section 8, that is by inheritance from the father. Now, each son, yes, 1/12, yes. Now, each son owned 1/3 of property, and that is separate property with respect to each other. Now, suppose S4 is born in 2004, will he be co-partner to the 1/4 property owned by his father through partition?
Yeah, whether father is alive or he is dead.
Father dies in 2002.
So father died. So there is no property in the hands of the father. How can the son, S4, who is born, okay, after the death of the father, then he can have a share. So that property, because the succession opens soon after the death of the person, the property cannot be without a owner. That is one important principle. Na? A property cannot be without a owner even for a fraction of a second. So as on the time of succession, so as on the time of the father's death, the property has been divided among the four sons. Suppose at the time of this partition, if the son was in the womb of the mother,
right?
Yeah, that son has always a claim to reopen the partition. So we have to presume that S4 happens to be the son of the father, who was at the time of the partition, or at the time of death of the father, he was in the womb. So his presence must have been taken into consideration while calculating the share. If it has been omitted and if it has been ignored, then subsequently when he is born, he has every right to reopen the partition.
Right.
Yes.
Yes, ma'am.
It comes under the topic reopening of partition. Who can ask for reopening of partition? Under what circumstances it can be asked? I suggest the student to go to that topic. Okay.
Reopening of partition.
Yeah,
All right.
reopening. Yeah.
Absolutely,
Then,
ma'am. Absolutely, ma'am. This marks the end of our questionnaire, question and answer round, and I think
okay.
we are ahead here, and this session is about to end. So first of all,
Okay.
I would really like to thank you for taking out time to address this much needed session, and also for answering the questions with such rigor. We
Yeah, it is
definitely,
my passion.
yes,
It
ma'am.
is my passion. Yeah. It is my duty also. So whenever demand, you can demand from the teacher, not request. You can demand from the teacher for sharing of knowledge. Okay. So whatever that is in my mind, I am here to share with you. And I really assure you that in future also, if you need assistance that is academic assistance, and you can take it for granted. Okay.
Absolutely, ma'am. We definitely need teachers like you who
Thank
teach with
you.
such dedication, and how well prepared you were with everything. And
Yeah.
you, yes,
It's my
yes.
duty. Yeah.
This was,
Yeah.
yes, this was a perfect example of how we need to approach our studies
Yeah.
and with how much
Yeah.
honesty we should study.
Yeah. We have to take it serious.
We
No, we
have to.
cannot.
Yes,
We have to take it serious, but it is worth taking. It's worth taking. Not at this. It may not be at this point of time, but in your profession, and you will excel all the others if you are very hardworking and you have learned everything, and you will excel others. You will have that confidence also. Okay. So
right.
hard work there is no what we can say, there is no shortcut for success. Yes. Take it seriously. I request all the students to take the exam seriously, whether the exams will happen or not. But accumulate the knowledge. Yes. Whatever that is there in the semester, you try to assimilate that knowledge and then proceed further.
Yes, ma'am. That's
Yes.
absolutely essential for us. And now, without further ado, I'd also like to thank the members of the team TSN for making
Yes,
this
ma.
event possible.
Yeah. From
Yes,
my side also, I extend the thanks to them, and I also extend my greetings for their hard work. And it is a novel initiative, because you are not doing for one student or section below, that is students belonging to one center. You are doing it for the entire faculty. So
yes.
I congratulate you. Yeah, my sincere congratulations and appreciations for the entire team. Yeah, keep it up.
We're grateful for this, ma'am. Thank you so much. And also, my expression of gratitude remains undone without thanking our viewers for their unstinting support. This means a
Yeah,
lot for us.
it is
Yes.
meant for them only. Okay, if there is no participant and the viewer, and what is the purpose of our session? Okay, my thanks are due to the students also, my beloved students also.
Absolutely, ma'am. So with this, we'll be ending the session for today.
Okay, thank you.
All right, ma'am.
Yeah,
Thank you so much.
yeah,
Thank you
yeah.
so much. Have a
Thank
great
you.
day ahead.
Okay, thank you.
Thank you, ma'am.